Hello everyone, and welcome back to another episode of the Darrell Brooks saga. We're gonna start the proper trial. I've been seeing in the comments that this is day 4 of the trial, and technically it is, but I say that it's day 1 because it's the first day with the jury, with the actual trial. But yeah, we're gonna continue with that. Also, I would like to give a shout out to our members. Right now we have 6 members, which is really awesome. I just wanna say thank you. I never really like to bring up members and donations and all that stuff because I'm not here to make money with these videos. Really, the fact of the matter is that I want to make you laugh. I want to brighten your day. That's my main goal of these videos. But there's people that have the means and I cannot really say thank you enough for supporting the channel because that allows me to get this like that I have here. I really appreciate it. But with that, I just want to say thank you guys for being here. You're great. You matter. And I'm glad that you're still with us. Alright, let's get right into the video. You always complain.
I appreciate your patience as the court addressed some important legal matters with the parties this morning. I'm going to read through the preliminary instructions at this time. Please pay careful attention. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, did cause the death of Virginia Sorensen with intent to kill that person and while using a dangerous contrary to weapon. Sections 940.01 sub 1 sub A, 939.50 sub 3.
The funny part about this is that we are just reading through the jury instructions that we were talking about all this time before. She's just reading it. And he's objecting for some reason. And I'm glad that she doesn't give him the time of the day.
3 sub A and 939.63 sub 1 sub B of the Wisconsin statutes. The second count of the information in this case charges November 21 of 2021 on Main Street in the city of Waukesha did cause the death of Leanna Owen with intent to kill that person. The third count while using a dangerous weapon in this case charges that Darrell E. Brooks, on or about Sunday, on Main Street, November 21 of 2021, Waukesha County, Wisconsin, did cause the death of Tamara. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21, Waukesha County, Wisconsin, did cause the death of Jane Coolidge with intent to kill that.
And by the way, this is the edited down version. You can see the whole video in the description below without my face and without the commentary. But she has 75 charges, I believe. So 74, something like that. So she has to read each and every one of those charges. So he just has to sit there and listen.
The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, Waukesha County, Wisconsin, on Main Street, did in the city of Waukesha of Wilhelm Hospital with intent to kill 939.50 using a dangerous weapon A and 939.63 sub 1 sub B of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, on Main Street, 21, in the city of Waukesha County, Wisconsin, did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous.
And I said this before in other videos that I believe that the Jason Sparks is the one victim that he feels bad about. I believe that he rationalized in his head that the other ones were kind of in the later stages of life, so he doesn't take those so much into consideration. But I believe that the kid is the worst one. I mean, each and every one of those deaths is bad, really, really bad, because he did it. But I think that's the one that he hurts him the most.
weapon, contrary to Section
Hello.
940.01, Sub 1, Sub A. The defendant has entered a plea of not guilty to each one of these charges. Of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on
This is gonna be my thumbnail. But this is look how ridiculous he is. Like, he got tired of holding up the sign and now he has it on his belly, I guess. And that means that he is perpetually objecting.
Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life.
It's ridiculous. Like,
and while using a dangerous weapon, sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.
And at this point, he even got rid of his headphones. Like, he doesn't need to hear anymore.
0.63 sub 1 sub B of the Wisconsin statutes. Waukesha County, Wisconsin, did recklessly endanger the safety of Patrick Heppy under circumstances which show utter disregard for human life. The 47th count, while using a dangerous of the information weapon in this case recklessly endanger the safety of.
We're almost there. We're at 47. We almost done. Remember, this was live in trial. This took like hours, I believe.
Lori Loken, under circumstances which show utter disregard for human life. 939.63 sub 1 B of the Wisconsin statutes. For a moment, I just want everyone to stand.
Yes. That was a long time. She needs water. Of course.
On Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of David Marquez under circumstances which show utter disregard for human life and while using a dangerous weapon. 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin sub B of the Wisconsin statutes. Did the defendant...
He's falling asleep while he's standing. Like, you don't need to stand. You can sit down.
Commit the crime of first degree recklessly endangering safety while using a dangerous weapon. Ladies and gentlemen of the jury, I still have many pages of my jury instructions yet to read to you. However, it's 11:54, and I would like to break, at least for the jurors, to have lunch. I have some legal issues I do need to take up with the parties, but when you come back, the court will continue where we left off with the jury instructions.
Yeah, I think it took from 2 to 3 hours for her to read the whole thing.
As I indicated prior to bringing the jury in, because of the process that was utilized for this court to approve of the jury instructions, and Mr. Brooks was provided with opportunities to object and provide input, I would not be taking a break or acknowledging, at least at that point on the record, any objection to those. Nonetheless, he held up his objection sign for much of the reading of the preliminary instructions. At 10:37 a.m., I received a note. I don't consent to that name. It is not me. It is not my name. Please let me object to this as it is my right.
So the whole time he was objecting because each and every charge has his name, like Darrell E. Brooks Jr. So that's why he was objecting, and he doesn't recognize the name on the paper. That is his name, but he doesn't recognize the name that is on the paper.
His objection is noted. I'm not going to take any further argument on that for the reasons I've already stated.
Good.
At 10:48 a.m., he sent another note. Are you going to acknowledge my objection? What law are you citing when you cite intent? How do I know it's what the law actually says?
Because you have to know the law to represent yourself. You don't get to ask the judge what it is. You should know.
I would once again refer Mr. Brooks to document number 244, the waiver of right to attorney form. This court is under no obligation and in fact cannot give him legal advice and is not required to explain court procedures or the law. Mr. Brooks is holding up the objection sign. I don't have anything in writing, which is the procedure that I told him he needed to follow in terms of me addressing any objections. So if he wants to write down what his objection is, and we'll file that. It's 12 noon. Let's be back here at 1 p.m.
And could he also have the opportunity to change into his street clothes if he wants during the lunch break?
Absolutely. During the lunch break, I'm told, will be seen by jail medical staff for the concerns that he's raised. He will be given the opportunity to change into his street clothing, should he choose. Of course, when he comes back, once again, invited back into this courtroom, should he choose. Mr. Brooks, if you're willing to abide by the rules of courtesy and decorum, you are welcome to come back. Would you like to come back to the main courtroom?
Can y'all hear me?
Yes.
You're on the record. Would you like to come back to the main courtroom?
He has to do the song and dance with the headphones for some reason.
And if I could just get confirmation from the bailiffs. I know the audio was tested. I was under the impression it was working.
It is.
Both audio and visual.
This is just wasting time.
Looks like Mr. Brooks has put on the headphones and they're testing them to see if they are working. I don't believe he had those on prior to the break.
No, he
My
didn't.
notes show he had removed them at about 10:54 a.m. and when we broke for lunch, it was about 11:54. So it was about the last hour of the morning session. He was not wearing the headphones, Your Honor.
Thank you.
And I do love that. I really love that Susan he has her eyes on him. She notes everything that he does. Like he cannot get away with anything because everyone's watching him. Everyone's fact checking him. So good.
All right, Mr. Brooks.
I really hate when he laughs.
I am offering you an opportunity to come back to the main courtroom. Would you like to do that?
Yeah.
I'm not sure why we're not hearing him very loud at the moment, but can you repeat that again?
I said yes.
You'd like to come back? All right, we'll have you brought back then. Thank you.
I would like to go back over there, Your Honor.
What? You just said that you wanted to be there. I was watching Rory for a minute because they were gonna bring him back, but now that he's back, he wants to go back again. What? What's wrong with you?
You would like to,
And I really like that he has the L on his chest. Like he has the loser initial in his chest right from the beginning.
you're asking that to voluntarily be taken to that courtroom.
Well, I'm trying to seek to understand how the testimony evidence that was given could be
Mr.
considered
Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction? That's still
No, there's no lawful motion before the court. You may not.
Yeah, you need to put that in writing if you wanted it addressed.
Are you making a judicial determination that I cannot?
Mr.
bring
Brooks,
that?
I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That
Yeah.
is not accurate, Your Honor. I
Your
respectfully
objection to my characterization of that is noted.
I would like to make a motion for finding the fact then.
Your request is denied.
On what basis?
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on what.
Mr. Brooks, you made a deliberate choice to waive your right to an attorney, which this court honored and granted.
That is inaccurate
And
because I
you
altered
Mr. Brooks, don't interrupt me. Okay, now that's at least the second time. So don't interrupt me. Even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It is not my
Mr.
intent.
Brooks,
It is not
please.
my intent.
I'm not going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I'm not
all right?
asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor.
She just told you that she cannot give you the understanding that you want. That's it. That's all she's gonna do. So tough nuts if you don't understand.
Don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I'm trying to bring up the subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you. The fact that you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
How is it not accurate? That's exactly what you're doing. Like, everyone can see it. Like, he always says, you're not in my head. You cannot know what I'm thinking. But your actions show what you're thinking.
My assessment will stand on the record, sir. It's based on my observations.
And
so at this point, Mr. Brooks,
I respectfully object
stop
to
interrupting me, please.
I merely
Stop
just seek
interrupting
to
me,
understand.
sir.
I was
If
in
you
the middle
have
of
an
saying
objection,
something.
write it down.
I thought that applied to me being.
It's
from
applying
another-
right now since you keep interrupting me while I'm talking.
So what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Good.
Is there
All
a
right,
reason why?
I'm not giving you advice. I'm not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I've addressed every single filing on the record. It may not be to your satisfaction,
That's inaccurate.
but I have addressed them.
That's
All
inaccurate,
right,
Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be. But we are continuing on with the reading of jury instructions. Madam Clerk, have the jurors brought in, please.
What you're doing is judicial misconduct. You're making the judicial determination, and I'm not allowed to ask questions. And I'm not.
Yes, that's the thing. You're not allowed to ask those questions. Maybe you can ask some questions, but not those, because he already told you that she's not going to answer them. And also, it's really disrespectful to tell a judge outright that they're doing something about judicial misconduct. That's really disrespectful to a judge.
Not allowed to question Your Honor, which is my right.
It's not.
I've merely brought up subject matter jurisdiction because it has merit. I've merely
Yes, and she told you to write it down.
tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings and I should be able to.
He has no idea what rushing to judgment means. How is she rushing something by putting you out?
To understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity.
Yes, you asked, and she answered the way that she's going to answer, but you keep asking after she answers.
Waiver that you speak.
It's the same thing when she asked him a question and then he answered whatever he wants to answer with, which is not what she wants to. A yes or no question, he answers with a long story about something. And she says, I already answered what you asked me. Now she's doing the same, but she doesn't like it.
Speak of with the attorney, I gave the right the waiver back in the way that I felt that it should be altered, and you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you.
Yes, she said that you cross out that word, but she also put on the record that in the bottom of that page, of every page of that document, it said that it couldn't be altered. So that denies everything that you did to that document.
That should have let you know right there further that I did not understand the proceedings, and that was some of the issues that I'm bringing up now. It's merely just clarification, Your Honor. I don't understand what is going on. It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the proceedings.
do you understand when I tell you not to interrupt me?
No,
do you
I
understand when I tell you?
Like that, and that right there, that shows the what is the word that I'm looking for? Disingenuous responses that he does. Like, she just told you, do you understand what it means? Do not interrupt me. And he's like, no. Any appellant judge that listens to that is gonna be like, this guy's a clown.
You need to follow the rules of decorum. I believe you do. Please sit down. The jury's coming in.
Boom.
I still would like to
Mr.
ask
Brooks?
questions, Your Honor.
Stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect,
Mr. Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Yes, she has, but not in the way that you wanted her to. But she has addressed those.
Mr. Brooks, the jury is in the courtroom.
I understand that,
you
Your Honor.
continue to talk
Hey, he understands something. That's new.
despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It is my right.
Mr.
I'm
Brooks,
merely
you
exercising
can
my
stand.
right.
You need to be quiet. Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks, please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking to understand, Your Honor.
Mr. Brooks, final warning.
I'm seeking to understand, Your Honor.
Take him out. Get him out of here.
It must be some clarification.
Mr. Brooks,
Shut up.
I want you here.
I want to
Stop interrupting me.
be here. You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor,
Ladies and gentlemen of the jury, I'm going to continue with the jury instructions. You must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 52, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 52. If you find the defendant guilty of count 67, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? And just for a moment, since I'm going on to a next section, let's just stand for a minute.
Everyone's gonna stand, he's gonna sit down.
If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 73, you should find the defendant guilty of hit and run as charged in count 73. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jackson Sparks? The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, and battery. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75. The 76th count of the information charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, Waukesha County, Wisconsin, did cause bodily harm to Erica Patterson by an act done with intent to cause bodily harm to that person without that person's consent. The parties will make opening statements. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show, so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Before we have the parties, or before I give them the opportunity to make opening statements, I am going to excuse the jurors to address a few legal matters, give you an opportunity as well for a short comfort break. We'll let you know when we bring you back in. Go ahead, sir.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right now, so I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by?
And that's true. Someone did flip him off when he was coming out of the trial. There's a video out there. I've been trying to find it, but it's really hard to do. But yeah, someone did that, but it wasn't that juror.
Your Honor.
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay. You do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs. So there was no way for me to even see who the jury was. Obviously, I wouldn't know him by name.
This shows how clever he is. Like this moment right here shows that he's not dumb. That his brain works. He doesn't show that very often, but his brain works. So, and what he's doing here is telling the judge that he recognized her. I don't know why, but he seems to recognize her.
I would have been able to see the jurors. I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. Do you know the number of the jurors, sir? They have numbers.
I just know that I can't see the number from here. I just know the chair she was sitting in.
Which chair, sir? Top row or the top or the bottom row?
The bottom row, the last black chair. Black shirt. She had the black shirt.
They're all
on.
black chairs, sir. So
The last black chair closest to the television.
I really hate how he does that. Like, that's so disrespectful in the way that he's telling stuff. She's asking for a clarification question.
Thank you, sir, because there are two sides, right? So there's the last chair on both sides. So I wanted to make clear. You're saying the chair closest to the television. Thank you.
I said that at the beginning, Your Honor.
State have copies of the filings.
Yes.
I will take these in order. The first is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both are by affidavit, filed 10/3/22, which today is deadline to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings. That's my decision, sir. Next
Are you
topic.
making a judicial determination that those have no merit?
Mr. Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for finding of fact.
Your request is denied. The next,
May Your Honor explain why
Mr.
it's
Brooks,
not.
later on, if you think I've made an error, you can then raise that on appeal.
I know you're making the error, Your Honor.
Mr.
You wanna
Brooks,
explain
I'm not going to
me
have a debate with you right now. We
I'm
are
not-
continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. The next piece of paper filed at 1:52
why? I still would
p.m.
like a judicial. Are you making
says,
a
are
judicial
you making a
determination?
judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. You do not have a right to disrupt the proceedings.
That was not
And
disruption.
Mr. Brooks.
I was asking, will my First Amendment right, which is freedom of speech and the right to be heard in court, will that be honored by Your Honor? That's
How is not being honored? You're talking right now. She's not shutting you up. She's not. She's even allowing you to write stuff down and pass it to her. That's freedom of speech. So how is that being ignored?
a valid question
Mr.
because
Brooks,
that's a constitutional
I have
right.
given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
I can't even
So-
get these admitted into evidence.
No,
That's
because
Mr. Brooks.
because they're nonsense that you just write. It's not legal. You don't have to file anything. That's not evidence. Even if there's something related to the case, you wrote them. That means that they're hearsay.
I cannot explain to you if you don't understand the basis in law for the denial.
You're right. I don't understand.
Yeah.
But
So,
I was
but that
following-
doesn't mean we're going to have a
I was
discussion
following- no,
or a
I'm not
debate
trying to debate
about
with you,
what
but I
it
was
means, because we're
following-
not
I
going
was
to
following
do that.
the rules that you set
So the bottom
by
line is, I
writing
don't
and
feel,
sending it.
Mr. Brooks, stop talking. I do
No,
not
I was
feel,
right. I was following the rules when you said that I had to make all
and you
objections
did, and I'm going through
in
them, so
writing.
please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr.
All I'm
Brooks,
saying is,
I'm going to address the next one,
what
so
you-
please pay
What you
attention.
were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr.
That's all I'm
Brooks,
really-
again, you have
That's something that he doesn't understand. Freedom of speech is not say whatever you want anytime you want. And at some point, the judge makes the example that you cannot yell fire in a crowded theater, because that's not freedom of speech. You know, there's some things that you, sometimes in places where you cannot say certain stuff. I mean, you can, but it's not correct.
Have the right to present a defense, but that right is not unfettered. That right, Mr. Brooks, you are interrupting me. Stop.
Because you're talking about
no, because you're purposely doing this, so I can't get my reasoning out. You make it incredibly difficult.
I'm not referring to the Sixth Amendment.
Mr. Brooks,
to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
Scratching something out of a paper that says there cannot be modifications to the paper doesn't make it right.
Mr. Brooks, I made findings regarding that, and those findings stand.
Yeah.
That despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right now.
You also accepted the terms of the paperwork that I filed out.
Mr. Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Or engage in any type of that kind of dialogue, because that's what you're claiming through some of these filings, and you've said that previously.
I'm not claiming that, Your Honor.
Yes, you are.
So,
in any way,
Mr.
shape,
Brooks,
or form,
I am giving you some leeway. I'm asking you to follow the rules of civility. Simple rules, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions?
I love that she's like, I let you do this. I let you read this. You didn't let her do anything. She's doing it because she can, and she will.
Follow the rules that you said I have to write down.
You did.
Anything that I object to, and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's being asserted.
Here's what's happening, sir. I'm telling you, I'm advising you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present. So I'm gonna, if I need to, I'll remove you to the other courtroom so that I can do this. And yes, exercise the mute button, sir. And then I'll bring you back when the jury's back.
This was filed, though, Your Honor, and it's a valid.
Mr. Brooks is clearly not following the simple rule of civility that I have established. He continues to interrupt. He's not providing this court with ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your Honor my First Amendment right?
I'm not answering that question, sir, because I've already addressed it.
So you're making a judicial determination to deprive me of my constitutional right?
I am not making any such determination, sir.
So you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I
already answered the question that you have a right to present a defense.
That is the
You have a right to be present.
You're trying to twist
You
up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Yes, they
your
are.
Rights,
He doesn't know what unfeather means.
You're citing the Sixth Amendment, which I am not
Mr. Brooks,
questioning.
Your First Amendment, in some respects, is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So that doesn't
freedom of
mean you
speech?
get to say anything that you want in front of a jury.
Your
And it
Honor.
doesn't mean you get to put forth any kind of evidence that you want
Your
in front
Honor,
of a
am
jury. What it means, sir,
am I
is
being
that
disrespectful?
you must
Am I
follow.
calling you
Yes,
out your
you're being
name? Am I threatening
disrespectful because
anybody?
you're
I'm
not.
not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm going to find that he's forfeited his right to be present as I go through
I have not consented to any.
his paperwork. He's to be removed to the other courtroom until such time as he can pledge to follow the rules of decorum and civility. We'll be in recess until we have
Your Honor,
everything
I do not agree to a
The
estoppel.
record to reflect, I'm stepping off.
Yeah, he doesn't agree to estoppel. Whatever. All right, that's gonna be it for today. Check back tomorrow for another episode. We're almost done, and after this, we're gonna continue with more different trials. But yeah, thank you guys so much for watching. Have a good day. Bye bye.